to be tabled in Parliament. I don't understand why our Parliament, and by the way, I'm one of those judges who is not limited in expressing my mind. So you not expect me to say Parliament has done wrong, the President has not done. I speak my mind because I don't understand why, for example, we are busy passing legislation very quickly on other subjects that are politically important, but we don't look at what is extremely important for this country. The Electoral Commission. How can a country like ours stand on its feet if it does not have an Electoral Commission? Elections are in 2027. This is 2024. When will this commission be prepared? Of Kenya, and I lead on IT, having a big conversation around the use of AI generally in the judiciary, and of course, we are heading to another election in 2027, where technology will be a big part of the work that we shall do post the election. My brother, the Supreme Court Justice Smokin Wanjala, calls himself a prophet. And he keeps saying, I prophesy there shall not be an election petition after this election. And I say, I am the prophet of doom. There shall be one. So we must prepare ourselves. I think like somebody said, how do we prepare ourselves? Because as technology continues evolving, we must be prepared and think ahead. Even if we don't, even if we can't manage, we must think ahead of technology. By way of introduction, my understanding of AI is that it is evolving, but is largely unregulated. So the conversation in Silicon Valley and other places is how to create AI tools, and in the government offices, how do you regulate these tools? And in the context of elections, increasingly both electoral management bodies and judiciaries must develop plans to respond to, and in some cases, use AI to maintain free, fair, and secure elections. On the part of the judiciary, certainly, we must think ahead and ensure that we are prepared and to ensure that automated or AI-enabled systems enable fairness, accountability, and transparency. We also must be aware of a phenomenon called trial by media. When this statement was first used in my own understanding during the O.J. Simpson trial, it was TV, not social media, not any other kind of media. And we know in the O.J. Simpson case and even the Michael Jackson trial that social media often are used to express strong opinions about ongoing cases. And these opinions can go viral, influencing broader public sentiment, but more fundamentally, they create parallel public trials. And these parallel public trials can complicate the judicial process and impact on judicial independence. And so judges must ensure that they remain insulated from such external pressures, because this is vital for the integrity of the judicial system. You may wish to know that last year when we visited Brazil, we had a long conversation with judges of the Supreme Court of Brazil around the question of use of ChatGPT and AI. Shock on us, when we returned to Kenya, one of the judges who was with us underwent disciplinary proceedings because he used ChatGPT to write part of his judgment. And so when I had a conversation here that there is need for us to have guidelines, we in the judiciary of Kenya are having a conversation internally to ensure that we have guidelines, because we know that judges are using ChatGPT, lawyers are certainly using it. I forget about your daughter or son. Advocates are using ChatGPT, and then it's worse than what I saw in cut and paste. Cut and paste was easier to detect, but my friend ChatGPT is in another world. So we must also review as a group and as stakeholders judicial independence in the face of cyber attacks, misinformation, and disinformation during elections. If it was bad in 2022, I promise you, again I prophesy, 2027 will not be any easier. So to the judiciary in electoral dispute resolution, you know the terms of the Constitution, you know the jurisprudence on the elections, but I think we must have a conversation around 2013, 2017, 2022 elections, because those are the ones that will teach us where we are going. The Supreme Court in all those 3 elections, or 4, because 2017 had 2 presidential elections, settled some of the issues around electoral jurisprudence. The normative derivative question, the burden and standard of proof, the counting of timelines within the Constitution, the nominations process, the conduct of repeat elections, and the distinct roles of the chairperson, co-chairperson of the IEBC and IEBC. And that's an important point because of the issues that happened in 2022. Kenya also, between 2007, after the Kriegler report, and 2022 in the last election, we now know that technology has come to the fore. And we only touched and scratched the surface in 2017, but you know that 2022 was principally around the electoral process in the context of technology. And whereas in the Constitution, Article 86, which is now becoming the anchor of all presidential election petitions particularly, we must realize that in the use of technology by IEBC, the question remains, has that use of technology met the standards of integrity, verifiability, security, and transparency? And I again prophesy that in the 2027 election, there is no doubt that technology will be the functionary and core question that we must address in the election petition subsequent to the elections. Those of you who followed the Rigiji saga will remember that at some point, the judiciary website, the online filing system, went down. I want you to carry this question into 2027. Why did that online platform collapse? Why did the firewalls that we created before 2022 suddenly become vulnerable? And imagine what may happen in 2027. I will say no more, but think about it. Let me quickly speak about disinformation and misinformation in the electoral cycle. And if I repeat what others said yesterday or this morning, do forgive me. I was not invited yesterday, neither was I invited this morning. I was invited to be here before 11. So blame Felix for all my mistakes after now. We know that social media platforms enable rapid spread of information and ideas, often bypassing traditional media gatekeepers. And you know the fight between Tuko, Kenyan News, and The Nation. Traditionally, the traditional media groups are struggling, and you saw the demonstrations outside the Standard Group yesterday. That tells you things are thick, and social media is taking over the media. This democratization of information dissemination can have both positive and negative consequences. On one hand, and Shakira, thank you for being here, it empowers individuals and marginalized groups to voice their opinions and mobilize support for various causes. On the other hand, it obviously also can lead to the spread of misinformation and echo chambers where users are exposed only to views that reinforce their own beliefs. This phenomenon has significant implications for judicial independence, as public opinion shaped by social media can pressure judicial outcomes. Not every judge has a thick skin like the Moran from SAMBURU called Lenaola, who has suffered tremendously in social media. Many judges do struggle with the effect of what is said about them on social media. I think my skin is worse than that of a rhinoceros. It is very thick. And I'll tell you why in a bit. You know that in Kenya by September 30th, 2022, there were 60 million mobile phone devices. That is higher than the population of Kenya, connected to mobile networks in Kenya, out of which 32.9 million were feature phones, while 27.9 million were smartphones. The use of mobile phones is a huge thing. It becomes bigger as we go to future elections. Contrary to what people think, social media is huge. Even my Shamba guy in Manyata, I see him on all these social media platforms because 10.5 million Kenyans by January 2023, which is 19% of the population, are connected to social media. And the radio, therefore, even for Luyas, Where is this? Even the radio for Kinamukwanja is no longer where they send salamu. They send salamu through social media. And we know that in Kenya, general elections are characterized by heightened political fervor and providing fertile ground for the proliferation of misinformation and disinformation. And both actors within and outside the country deploy false narratives to sway public opinion. Cambridge Analytica. And you know what went on in America? The role of Russia in disinformation and misinformation during elections. Who tells you we are not next? The European Union Election Observer Mission final report in the 2022 elections pointed out that online space was distorted by extensive and sophisticated disinformation campaigns targeting multiple election stakeholders and largely seeking to undermine public trust in the electoral processes through repetitive attacks on the IEBC and its members. And you know that after the, during the petition for the presidential election petition 2022, judges took a lot of flack, myself included. 9 Twitter accounts were opened in my name. 9 Facebook accounts were opened in my name, including one which had the picture of Vera Sidika. Why they chose Vera, who I don't know, I don't know. But if you go to Facebook, I've tried to remove all others, but if you go to my Facebook account, just type on Facebook, Isaac Lenaola, Vera Sidika will appear very buxom-like. And you can see I don't have much of a waist, so we have no commonality. And the effect really is that it is the intention is to threaten, to intimidate, and to ensure that the judgment of the court goes a particular way. And that's not just myself, but also judges of the court. Hashtags were extensively used by parties to push narratives, create trending topics, criticize opponents, and spread disinformation campaigns. In one of my social media pages, what they would do is they would post as if it's me who has posted. And then now they post, they populate it with attacks on the court, attacks on me, in ways that I would be very, very surprised that they did. So in 2022, and certainly in 2027, there was a significant increase in disinformation and hate speech online, circulating on various media social platforms and across all the other platforms. Responses by key stakeholders on these things were very, very poor. The role of the National Council on National, what is Kobia's outfit called? Cohesion and integration was zero. They took too long. IEBC was busy conducting the election or organizing the election. IEBC similarly had difficulties managing the language of social media. We also know that no reports of warnings, arrests, or investigations relating to such problematic content were made, and we know that in fact very few were ever arrested for those things. I had in my paper the legal framework for all these things, the Constitution, the Defamation Act, the Penal Code, the Computer Misuse and Cybercrimes Act. But I thought I should probably speak about one case which is important around that question, which was the Bloggers Association of Kenya versus the Attorney General. The attempt was to declare the Computer Misuse and Cybercrimes Act unconstitutional because the bloggers were saying, you are limiting our right to expression and that whatever we say should not be limited. And the court found it difficult to agree with them, and that's an important discussion we must continue having. Someone spoke about deepfakes, robotics. You may wish to know that the Kenya Robotics and Artificial Intelligence Society Bill 2023 has been written, but is yet to be tabled in Parliament. I don't understand why our Parliament, and by the way, I'm one of those judges who's not limited in expressing my mind. So you would not expect me to say Parliament has done wrong, the President has not done. I speak my mind because I don't understand why, for example, we are busy passing legislation very quickly on other subjects that are politically important, but we don't look at what is extremely important for this country. The Electoral Commission. How can a country like ours stand on its feet if it does not have an Electoral Commission? Elections are in 2027. This is 2024. When will this commission be prepared? And where is the legislation that the Supreme Court has said over time, write a law on this, write a law on that, prepare yourselves in advance. And then in 2027, suddenly, our courts are inundated with petitions, striking out parts of legislation, saying they are unconstitutional, and then when the courts don't make decisions in 24 hours, you say the courts are the problem. We are not the problem. Why is Parliament not writing these things now? If we write these laws in 2024, by 2026, the Supreme Court has settled. But if you write them in 2026, they'll come to us in 2029. So 2027, we shall continue struggling with bad legislation, which does not speak to the time of the election. Why do you blame the courts? Someone also spoke about deepfakes. And I don't know whether it was spoken to in detail, but all I shall say is that deepfakes is the next horizon of threat. We in the courts must therefore be prepared to know how to deal with deepfakes. Are our laws clearly appreciative of deepfakes? Are we as judges well trained to know the difference between deepfakes and reality? And so the Law of Evidence Act speaks to things that were happening in the 60s and 70s. There is no law around deepfakes. But nobody's speaking about the need to have laws about things like deepfakes and for judges to be trained on deepfakes. So in my paper, I've tried to, and when I circulate it, you'll see what I've tried to do. I've tried to show how we can use existing legislation, like the Computer Misuse Act, to manage the reality of deepfakes. We have gone a bit in terms of generation of electronic evidence, but how do we address the reality of deepfakes? My paper was really about the next subject, which is this. How does digital media, including AI, affect judicial independence? We know that judicial independence requires that judges must make decisions based solely on the law, facts of the case, free from external influence. But social media, by amplifying public opinion, can indirectly challenge this principle. A clear depiction of social media influence was seen after the pronouncement of the 2017 nullified elections. Those of us in the majority of 4 who nullified the 2017 election suffered incredible social media barrage. And this brings to the question, how prepared are judges to suffer through such attacks? I recall, for example, the hashtag justice for sale, hashtag we shall revisit, and these things, judges are human. If at my age you're told we shall revisit by you know who, you start wondering, is this the time that I cross to Ethiopia, which is nearer my village, and start herding my cows there, or do I remain in Kenya and go through these things? And these things are important for us to think through. So what are the issues that arise in the interplay between social media and judicial independence? Number 1, public's perception of the judiciary will suffer. Social media influencers use conspiratorial narratives such as judicial capture, judicial corruption, to influence voters and the court's decision. Such narratives impact greatly on the image of the court by the general public. The administration of justice will suffer if as soon as I walk out of court, they say, huyo ni corrupt, huyo ni captured, huyo ni. We cannot afford to have the administration of justice suffer. Truth be said, if the judiciary of Kenya were to collapse today, believe you me, the state will ultimately have to collapse. Because the judiciary of Kenya, even if you don't agree with me, I will still say it, has stood firm in the face of incredible pressure from all sources, including from civil society. And I think we need to be grateful for that. Number 2, amplification of judicial opinion and judicial pressure. When I joined the judiciary in 2003, we were completely insulated from public opinion because we didn't have all these things that were now happening. And so we're able to maintain impartiality. But now we find ourselves, not a bad thing by the way, we are now finding ourselves subjected to intense scrutiny and criticism on social media platforms. Some is true, but some is outright lies. After 2017, I woke up one morning to the very interesting news that I own a 15,000-acre ranch in Laikipia. I wish I have such a ranch. I would not struggle making speeches at Kempinski. I would go and look after my cow, sit under a tree, and drink a fine cognac. But look at me now. So this amplification has a huge effect on how judges make their decisions. I have over time, because I lead on technology in the judiciary, I follow all social media sites. I receive information from all manner of sources. And I see some judges of the High Court buckling to pressure from social media. And the day judges buckle down to pressure because of populism. So you make popular decisions because you want to be popular on Twitter, you want to be popular on Facebook, you want to be popular, and I'll come to TikTok in a minute. You are not an independent judge. And so people may not know, but the younger judges who have not had the experience, who have not gone through the test of fire and brimstone, they can buckle, and that impacts on judicial independence, and that is wrong. Reputation and career of judges. Social media can play a positive role in shaping the careers and public personas of judges. When I was still popular on social media, I felt very nice. When they say Lenaola is a jurisprudent, Lenaola, when you sit in his court, you really enjoy how he manages his court. Now when they say things about me, I say, is that me or another person they're talking about? But judges who become subject to social media attention, whether for their rulings or personal conduct, may find their reputations significantly impacted by the narrative formed online. Now if you look at my social media page and you see me with Vera Sidika, and I have no problem with a good lady, what do you think of a judge like me now being that, you know what I mean? So sometimes it's important to have a positive attention to judges' careers, give them what is due to them, criticize them properly. Yesterday at Strathmore, and some of you may have seen it, when I spoke at Strathmore University yesterday, I specifically said, we as courts would rather that somebody wrote a piece in a newspaper, in a magazine, online, which is reasoned, a critique of a judgment, which we can look at and say, yes, we made a mistake here, how do we reform ourselves? But if you go to this to social media, and there are 2 lines on Twitter where you say, juris pesa, what does that do to the court? What does it do to the public? What have you taught the public? How does it help the administration of justice? But if you write, and Adams is here, if you write a scholarly paper, if you look at the Platform magazine, Nairobi Law Monthly, before it was taken over by my friend, the articles were fantastic, and I read them daily, every month when they came, and some impacted on how I wrote my judgments because, for example, let me give you an example for those who are lawyers. I was in the Constitutional Human Rights Division from 2010 to 2016. And we were the first judges, Late Majanja and Mombingogi, who sat in that division, which was a very hard time for us. It's a new constitution, we have no precedents to follow, but we did a good job in my view. But we also made some mistakes. And one was pointed out to me by a student who wrote in the Platform. And I was very happy that he wrote it so well that I actually looked for him and said, thank you. I must have written this in a moment when I was not myself. But that is the way we should criticize courts, but not ruin careers and reputations. You may know that, for example, Chief Justice Maraga. Chief Justice Maraga served as an advocate, as a judge. We were appointed together as judges in 2003. He became my Chief Justice. We were appointed together to the Supreme Court. The man is retired, but he's having 3 defamation cases in court against my friend Grand Mullah. Both are pending before the courts. The Chief Justice has obtained injunctions for Grand Mullah not to defame me on social media. Why should we treat our judges like that? Even if you have differences with them. Even in retirement, you follow them. So my point is, let us not ruin careers which have taken time to build. The other point is the social media campaigns and legislative influences. We know that social media can impact across the board. But why don't we use social media to impact on legislation. Why don't we, for example, have a hashtag, appoint IEBC, now, and spread it? Those who have opportunity will actually follow it, and they will do something. Why is social media, why is the IEBC not being constituted? Because Azimio can't appoint their representative to the panel. Is that something to hold a country hostage for 2 years? So how can we use social media positively to impact on legislation? How then can the judiciary itself, and I'm coming to the end, how can the judiciary play a role in combating misinformation, disinformation, and deepfakes in elections? Number one, the judiciary must reverse the narrative. Building trust in the judiciary's impartiality is crucial for combating misinformation. And the judiciary can reverse this by public communication and effectively using the social media handles to set out the truth information to the public. I also sit as the chair of the Judiciary Communication Committee, and that is one of my more difficult jobs as a judge. We have been unable to answer back to the narrative. We don't have a strong communications directorate. We don't have people who are qualified, and we are struggling to answer back. And yet, as a judiciary, again, we can't keep answering everything. When do you choose who to? Can we, for example, again, my friend Ahmed Nasser, he wakes up every morning, and it's Chief Justice and the Supreme Court. Now, are we supposed to now respond to him every morning on everything that he says, or we let him have his, enjoy his moment of fame on social media? So again, it's a difficulty we have, but the principle that we must respond appropriately must stand. We must also advocate we as a judiciary must also set precedent in how we deliver our decisions. If the public can read our decisions, if the public can understand our decisions, then any misinformation would be addressed by them understanding it. And so what we have done in the Supreme Court, for example, is we have media summaries. Media summaries are brief because look at the BBI case. The judgment was 1,200 pages. Which Kenyan can sit between tafuta mboga and bread for the day, read a judgment like that? So we summarized it in, I think it was 5 pages, which was very easy to read. In the judgment for election petitions, we also do the same. If we as a judiciary continuously update the public in a simple, understandable language, we should be able to get out of the woods. Legal reforms, I've just spoken earlier about the need for not closure of digital media platforms, not harassment of Shakira and her people, not arrests, not abductions, not kidnappings. We can regulate it in a manner that is constitutional and balanced, so that Shakira and her people can have the right to do what they have to do, but they must do it within the binds of the Constitution, and even us who are the subject of attacks must be able to enjoy our rights without breaching the Constitution. The other thing is capacity building. I think somebody spoke about training of judges, and I said a bit of it now. There's absolutely, it's important that the Electoral Commission, the media, civil society, ourselves, we must develop capacity of understanding all these issues. Lilian Mahiru, you know that before 2022, we called the commission together with the Supreme Court. We did a run around how the electoral process is. I think you were there. Fantastic process. If we can engage with each other, there is no need for us to be enemies of each other. The media, we can have media breakfasts where they understand the role of the court and the media explain to us their role. Civil society, Felix and his group, we worked together through the years, and every pre-election period, we have a training to discuss the process of elections. We invite the likes of Adams, we invite the likes of Collins Odote, and we learn a lot from each other, and the judges are more. Let's continue doing that. I'm rushing through to the, so I would have spoken about social media platforms, addressing human rights, civic education, and digital education. Those are clear issues. I would like to close by saying this. My friends, artificial intelligence, social media is here to stay. Mupende, musipende. What we need to do as a country and as a people is to start working towards institutionalizing these processes within our own processes. This idea that we wait for the UK to do something, then we follow, wait for the US to do something, then we follow. Half of the fellows in Silicon Valley are from India and Africa. What business are they doing there if they don't help us develop our own systems here? So they send money, something called diaspora remittances. PLO may kill me when I say this. PLO Lumumba will kill me if I say this, but Adams do be my agent. When PLO ran for member of parliament for Kamkunji, there's a small book PLO wrote about that experience. PLO went and then he spoke good English. He's a guy from Eastland, so he speaks good Sheng. They told him, what is that Luo word for give me? Gonya. So PLO told Gonya. PLO said, no, we are talking ideas. We're talking democracy. We're talking... He was told, we can't eat your English. We can't eat your... we can't eat your English. We can't eat your Gonya. We need Gonya. And PLO lost to Simon Bogwa. So, but the bigger point is our friends in Silicon Valley in the US who have all this information, they can send us, they can go on us the diaspora remittances, but they also bring the intellectual input into the country. Number two, the judiciaries must continuously leverage on technology by adopting AI and forensic tools to detect deepfakes, verify authenticity of digital evidence presented in courts, create partnerships with the cybersecurity experts to safeguard judicial data and electoral systems from digital threats, because it's a reality we must face, and I told you, I warn you about what may happen in 2027. Let me then close by saying this. If there's nothing to come out of this conference, this workshop, it must be the answer to the question, where shall we be in 2027 in terms of AI and elections? Where shall we be in terms of deepfakes and the election of 2027? Where shall we be in terms of cyber attacks in 2027? Where shall we be in terms of the process of IEBC in 2027? Where will our judiciary be in terms of adoption of these forensic tools by 2027? If we don't answer those questions, don't blame anyone if something doesn't go right in 2027. But remember what happened in 2007. Because our friend Raila Odinga said he does not trust the Kibaki courts, no election petition was filed to challenge the election. And Kenya banned. Whatever we think of our judiciary, whatever we think of our IEBC, whatever we think of ourselves as a people, let us use existing constitutional process to manage our disputes, to manage our challenges, because only then can Kenya remain a democracy. Only then can Kenya go far in terms of its democratic institutions. I thank you for your attention.